Hello and welcome to episode 54 of On Liberty. I'm Monica Wilkie, a policy analyst here at the Centre for Independent Studies. Today I'm delighted that we're going to be talking to Vice President of the Rule of Law Institute, columnist for The Australian, and first-time CIS guest, we finally caught him, Chris Merritt. Chris, welcome to the show.
Hi there.
So today we're going to be talking about all things ICAC, which is something that Chris has written about extensively. So to kick us off, Chris, I think it would be good if you could just give us a very brief outline of why ICAC was instituted and whether in the beginning you think it was justified.
Right, it was definitely necessary. The logic for it was compelling. We've got to go back to 1988. New South Wales was reeling from massive, significant corruption problems. Going to the top of, not the top, but very close to the top of the judiciary, politics, all over the place. It was just horrific. Nick Greiner, when he was in opposition, promised to do something about this. Gary Sturgis, his chief advisor, primarily helped design this thing. At the time, and we're talking 1988, it was absolutely necessary. The top priority was to restore the standing of New South Wales. It was a bit of a laughing stock in the entire country. It was basically poking fun at New South Wales. So it was necessary. But in retrospect, it's become very, very clear that the purpose, which was to restore the standing of New South Wales, that purpose is still there, but it's a different problem now. The problem has been that the powers that were vested in this commission were extraordinary. So they abandoned rights and privileges and procedures that have grown up over centuries for good reason, to protect individuals when they're hauled before the justice system from an abuse of power, to ensure that everyone was treated fairly, that the state, with all its enormous coercive power, was not given a complete upper hand, that it was a fair fight whenever people were accused of wrongdoing. At the time, it was necessary to crack down on corruption, and those rights were given very little weight. And you can see this in Nick Greiner's second reading speech at the time, which I've gone back and had a look at. He reckoned that the big problem would probably be, he expected there might be criticism, but he hadn't gone far enough in empowering this new organisation. Come forward 2 or 3 decades, and what we've got is an organisation that its interests have become absolutely overwhelmingly important to both sides of politics. Just go back to 2014, 2015. 2014, there's two pieces of legislation that really disclose the impact of this commission. 2014, there was expropriation legislation, which took away property rights from 2 mining companies, New Coal Resources and Cascade Coal. After an ICAC inquiry, spectacular ICAC inquiry, where there were front page stories for weeks and weeks and weeks about massive corruption in the state. Barry O'Farrell was Premier. He raced straight into Parliament and said, look, this is terrible. These coal exploration licences were tainted by corruption. You've all seen what ICAC's had to say about it. ICAC had recommended that these coal exploration licences be cancelled and that compensation be paid to innocent parties. The problem is that, let's look at just one company, New Coal Resources. There were 5 findings of corruption to do with New Coal Resources. New Coal bought a coal exploration licence from a company called Doyle's Creek Mining. 14 months, it was 14 months after the licence was issued that New Coal emerged on the scene and bought this company. the accusation was that the New South Wales government, through Ian MacDonald, had engaged in an act of corruption with Doyle's Creek Mining by issuing the licence to Doyle's Creek Mining to benefit that company's chairman, John Maitland. Okay, go forward a little bit. They were convicted of misconduct in public office, and in 2019, their convictions were quashed. They'd been to prison and their convictions were quashed. They're still awaiting retrial. So there's no finding of wrongdoing about those guys. So what about the others? There were 3 other people from Doyle's Creek Mining who were directors. One of them, Craig Ransley, was prosecuted twice. All these 3 were declared corrupt by ICAC. Ransley was prosecuted twice and acquitted twice. Okay, what about the other 2? Mike Chester and Andrew Poole were directors of DCM. They joined New Coal. They were declared corrupt. Neither of them were ever prosecuted. Chester was not even referred to the DPP by ICAC. Poole was referred to the DPP. Please give us your opinion on whether this fellow should be prosecuted. DPP came back and said, no, he shouldn't be prosecuted. No wrongdoing here. What about Chester? Chester never had an opportunity to get into a court and clear his name. He and the other 3 on the public record are corrupt, but they've never been prosecuted. Ransley, at least he had the good fortune, it sounds a little bit strange, but he had the good fortune to be prosecuted twice and twice to be acquitted. So his presumption of innocence is entirely intact. Yet he is corrupt, according to ICAC. All those things go to their reputation. But what is really worrying is that on the basis of these accusations of corruption from ICAC, Barry O'Farrell went into Parliament and shepherded through legislation to strip this company. This is New Coal, which, remember, New Coal didn't benefit initially from this licence. It was issued to a separate legal entity, Doyle's Creek Mining. New Coal comes along 14 months later, pays $94 million for Doyle's Creek Mining, and was quite happy to do everything it was required to do under the licence agreement with the government, which is prove up the deposit of coal, do all sorts of things, spend millions of dollars. I think it was about $40 million extra on exploration, geology, all sorts of things, core samples, to meet their obligations to the New South Wales government. They had gone and employed lawyers to check the veracity of the licence. Was this issued properly? Yes, it was issued properly. Then ICAC comes along, conducts an inquiry, and tells the government, oh, I'm sorry, this licence was not issued properly. So who suffers here? New Coal, which is effectively an innocent party with thousands of institutional shareholders and family shareholders in the Hunter Valley. American institutions had invested millions of dollars in this company. Families in the Hunter Valley and around Maitland particularly, where this company was based, had invested life savings in New Coal on the basis of, we know these people, we know they're straight shooters, they wouldn't have done anything wrong, and they didn't do anything wrong. But they're the ones who have been made to suffer. They've suffered the penalty of losing all their money. The value of this company has been trashed. Remember, they paid $94 million, then poured in an extra $40 million in their obligations to the government, and they've done nothing wrong. And how does this stand? The source of this goes back to ICAC. ICAC had recommended that because of what ICAC said was the corrupt nature in which this licence was issued, it should be cancelled. But ICAC, even ICAC, had recommended that innocent parties be compensated. But Barry O'Farrell didn't do that. His legislation, which is still on the books, by the way, prevents the payment of compensation. So you've got thousands of families that have lost their savings. You've got American, not just American, but Japanese institutions as well, who had invested in New South Wales on the basis that this is a state where the rule of law prevails, where if a company obeys the requirements set down in the Mining Act, that it's quite safe to invest and develop coal deposits, do anything that's permitted by law in this state. And that's been cast into doubt. Now, what about the original issuing of the licence? Remember, that was Ian MacDonald and John Maitland, both convicted of misconduct. MacDonald was convicted of misconduct in public office and Maitland was convicted of being an accessory. Now, their convictions have been quashed, ostensibly because of what many people would see as a legal technicality, because the jury was given an incorrect briefing by the judge on what the test is for misconduct in public office. And the Court of Appeal, a 5-judge Court of Appeal, a special Court of Appeal, which carries enormous weight, normally it's 3, it ruled unanimously that they reformulated the law on what is misconduct in public office. And that clarified a lot of the confusion about this law. The original conviction is, in retrospect, happened because of the confusion over the legal test. So this 5-judge Court of Appeal clarified the law and introduced what's called a but-for test. So if you're a public policy maker and you make a decision that benefits the community, but also has a collateral benefit to an identified individual or groups of individuals, before this but-for test was introduced, you were vulnerable. You could have been pinged by ICAC for helping a mate, which is exactly what the accusation ICAC made against Ian MacDonald. But the but-for test, it works like this. You can make a decision and it will be legitimate and valid as long as that decision would not have, how does it go? If it would have been made, regardless of the benefit that is bestowed upon this identifiable party, it's legitimate. But if you would not have made that decision, but for the benefit on this identifiable party, you're in strife. Now, where did that come from? That came from submissions made by legal counsel for Ian MacDonald and John Maitland, and that's the law. So if there is a retrial for these two fellows, it'll be determined on the reformulated law of misconduct in public office that has its origins in submissions made by these two men. Now, there's been no decision made yet on whether there will be a retrial, and I'm speculating here, but I suspect that the reason for that is that there are related proceedings which have not been finalised over the issuing of a licence to Cascade Coal, or a precursor company to Cascade Coal. Ian MacDonald again is involved. So I think what's going to happen is the judgment's now reserved on this one. It's actually expected very shortly. Justice Elizabeth Fullerton of the New South Wales Supreme Court has been considering her ruling for more than a month, getting on to 2 months. So it can't be too long, but that will determine whether the issuing of the licence that was eventually bought by Cascade Coal, whether that was affected by an act of corruption, by misconduct in public office. But in both these cases, in the new coal licence, which was taken away by the government, and the Cascade coal licence, which was taken away by the government, both those companies are effectively newbies. They came along after the licence was originally issued to another company. In New Coal's case, it was Doyle's Creek Mining. In the Cascade case, it was a company known as Monaro Mining. Cascade only got its licence after Monaro Mining was unable to come up with the $25 million it had promised to give to the New South Wales government in return for being allocated this licence. So the way I see it is this: even if the process of issuing both those licences, the one to DCM and the one to Monaro, if that process was tainted by corruption, why have penalties been imposed on third parties, companies that came along long afterwards and effectively bought these licences? New Coal bought Doyle's Creek Mining only to obtain the exploration licence and was then made to suffer a massive financial penalty, which...
I just want to jump in there for a second, Chris, because you've just outlined in excellent detail those two cases and the potential problems of them. But I just want to really focus on something for a second, because you've brought up a lot of issues. You've got these two mining companies that had their licenses taken away, reputational damage, families losing their life savings. Just would like to get your sense of how unprecedented is it? I mean, well, I suppose, is there a precedent for this? Is this, in a system like New South Wales, where we say we believe in the rule of law and these sort of things, how peculiar are these cases?
Extremely peculiar. Look, particularly when it comes to mining, New South Wales has taken back other exploration licences from multinational companies, Chinese companies, and has paid compensation. It's very strange, extremely strange, that companies and shareholders who have done absolutely nothing wrong have been made to suffer a penalty. Now, you just got to theorise, why would this happen? And I think the only possible reason is the massive publicity that had been associated with the original coal inquiries conducted by ICAC, 2013, 2014. Huge headlines all over the place. But when you piece it all together, the accusations that were made at those inquiries and the findings in ICAC's reports, they don't gel with what the courts are finding. I'll give you another example. John McGuigan is the chairman of Cascade Coal. He's a former global managing partner of Baker & McKenzie. He was declared corrupt by ICAC along with some other directors. Now, he was in the process of securing declarations. He and his fellow directors were in the process of securing declarations from the New South Wales Court of Appeal. Margaret Beasley, when she was president of the Court of Appeal, had circulated a draft declaration to John McGuigan, ICAC, and I think it was about 4 or 5 other people who were involved in this legal action, stating that ICAC had no authority to make corruption findings against McGuigan and others, that was beyond jurisdiction and a nullity. Now, fine, why didn't that go ahead? Because ICAC had, this followed, I'll go back five seconds. This followed a High Court ruling in a case involving Margaret Cunneen, where it was found that ICAC had misunderstood its governing act about its jurisdiction, misunderstood how wide its powers were, and had been making unlawful declarations and holding unlawful investigations. 128 people, I think that's the figure, had been affected by this unlawful declarations that affected their reputations without a proper basis in law. So McGuigan was, and the others were quite keen to get into court and clear their names. I mean, the former managing partner of a global law firm has a big interest in doing this. But ICAC was keen to avoid being shown to have misunderstood the law and have effectively breached the limits on its jurisdiction. So it went down to Macquarie Street when Mike Baird was Premier and had discussions. And as a result, Baird's government prepared legislation that retrospectively validated ICAC's unlawful conduct. It provided ICAC with a copy of this draft legislation the day before Margaret Beazley, who was President of the Court of Appeal, circulated her draft declaration saying, oh, by the way, McGuigan and all these others, those findings have no basis in law and are a nullity. ICAC knew before that draft declaration was circulated that the law was about to change and was about to change retrospectively. So the effect of that was in the morning when this law took effect, ICAC had engaged in unlawful conduct. Government solicitors had accepted this in correspondence with McGuigan and the Cascade parties. In the afternoon, when the law took effect, that unlawful conduct was disappeared, and ICAC had engaged in conduct that was valid by legislative fiat. Now, what did that mean? Well, it meant that all those people who were unlawfully tainted were deprived of a remedy. The doors of the courts were closed by legislative fiat. They could no longer go along to an independent court like anybody else and say, oh, look, by the way, I've been unlawfully damaged and I'm seeking a remedy. That's the role of the judiciary. The independent judiciary is there to provide remedies for people who have been affected by wrongdoing, unlawful wrongdoing. And in this case, the unlawful wrongdoer was an agency of the New South Wales government. And the New South Wales government, clearly fearing claims for compensation, simply changed the law. Now, what sort of signal does that tell you? If you're going to do business in the state of New South Wales and a government agency causes you unlawful damage, are you at risk of losing your rights, your access to justice? On the basis of this precedent, I'd say you are. It depends whether the government likes you or not. It also depends on whether it's in the government's political interest. And you've got to remember the media had gone along with this effectively. And I don't mind admitting, for a long time, I was a closet fan of ICAC. It was only when ICAC started pursuing Margaret Cunneen as a silk and is now president of the Rule of Law Institute that my eyebrows went up, because I knew Miss Cunneen a little and I now know her a great deal better. But what I knew was that she was no crook, yet here was she being pursued by this agency. So when you, anyway, long story short, those are my concerns, that there's been a very regrettable impact on public policy in New South Wales because of this commission. Now, there have been a series of reforms and restructures that have taken place since this time. Instead of one commissioner, effectively unworried by anyone looking over her shoulder or his shoulder, we've now got 3 commissioners, and to a degree, they've got to act in concert. They look over each other's shoulders a bit, which is great. That's great, but it's not enough. The problem with this commission is that it gets down to 2 things. They make public findings of corruption, which can destroy someone's reputation forever. regardless of whether the individual concerned has complied with the law and whether the courts in later proceedings validate that and say, look, you've complied with the law, you're not guilty of anything. Once you've got a corruption finding against you in New South Wales, it sticks. It's there indelibly. The only appeal against ICAC's findings is judicial review, which is a very limited grounds for review. It's whether the Commission has made an error of law, i.e. exceeded its jurisdiction, which is what happened in the Caneen case. It also happened to Nick Greiner by coincidence. That's why ICAC's original finding of corruption against Nick Greiner was struck down because they'd exceeded their jurisdiction in that case. But anyway, bottom line is there's no appeal on the merits. They can get their facts wrong, and that doesn't matter. As long as they don't make an error of law, you are indelibly corrupt forever, regardless of what a Supreme Court judge or a Court of Appeal might say. They might say, look, there's no criminal conduct here. You're free to go about your business. And in this state, not just in this state, but in this country, the presumption of innocence works this way. You're entitled to do anything you like, as long as you stay within the bounds of the law. Now, ICAC comes along and complicates that, not just complicates it, but basically qualifies it. So now we're in a situation where everybody who is not guilty of an offence is entitled to a presumption of innocence. But ICAC says, well, you can be entitled to a presumption of innocence, but you can be corrupt and referred to the DPP for an opinion. You can be corrupt and not referred to the DPP for advice on whether you should be prosecuted. You can be corrupt and found guilty by a court, and you can be corrupt and found not guilty by a court. Now, what's the purpose of a body of law? If the purpose of a body of law is to send a clear signal to the community about what your rights and obligations are, it doesn't work anymore, not in New South Wales. Your presumption of innocence has been qualified. It's been, you can be as innocent as you like until ICAC gets its hands on you and makes a declaration. And then you'll...
There again, Chris, because we're quickly running out of time. Just on your point there, we've got a question from one of our viewers that I think touches nicely on a couple of those issues there that you've been discussing. So question from Christopher, thank you for watching, is abuses of power by bodies like ICAC are inevitable unless safeguards are put in place. So I'll put to you, Chris Merritt, what safeguards would be sufficient?
Look, let's look at South Australia, one of the states with a commission. They've got an independent commissioner against corruption. No public findings, no public hearings. That means it's an orthodox part of the justice system. It investigates a matter thoroughly. It produces a report, and it doesn't declare that publicly, just like the police. The police conduct an investigation. They provide a brief of evidence to the DPP, and that's what happens in South Australia. So if the DPP disagrees or the courts disagree with what ICAC decides in South Australia, no damage is done. The supremacy of the courts, the supremacy when it comes to declaring rights and liabilities, that's the exclusive prerogative of the judiciary, or it should be. And that's how it works in South Australia, and that's how it should work here. That would mean that if ICAC makes a mistake or exceeds its jurisdiction and investigates something that it shouldn't investigate, and then hands all that material over to the DPP. And the DPP gives it to a number of lawyers, and they look at it and say, oh, gee, this is missing, that's not right, send it back. If they can fix it, well, maybe then we'll launch a prosecution, but until they can, let's not. All those errors in New South Wales are not addressed. ICAC can make mistakes in its public hearings, and there's no remedy. There should be a remedy. I mean, if you're going to have a public hearing and a public finding, at the very least, there should be an appeal on the merits, not just a limited appeal on a question of law, but an easier solution and a quicker, more efficient and orthodox solution. It'd simply be to do away with these public hearings, which we've seen in the case of Gladys Berejiklian, can rapidly descend into prurience. Let's have a look at the Premier's love life. Won't that be interesting? They'd already asked her a number of questions about this in private hearing, and then repeated the same process in public. And you've got to ask yourself, what's the public interest there? I don't think there's any. But that sort of reform, doing away with public hearings, making ICAC become part of the mainstream orthodox justice system, I think that would improve things out of sight. It would definitely mean that a lot of bread and circuses would disappear. Front page sensational stories that come out of ICAC's hearings would disappear, which is good. I mean, it's bad for the media to report things that subsequently are shown to be baseless, and that's in the Cole inquiries. That's what's happened. The media has been hoodwinked essentially into reporting these findings as if they were findings of law. Remember, ICAC adopts the outward appearance of a court, bow to the commissioner, it's set up like a courtroom. It's not a court. It's stripped of the checks and balances and procedural safeguards that mean the courts deserve the respect they get, whereas ICAC is a commission, not part of the judiciary. It's part of the executive branch of government. It's caused a massive amount of confusion. If it were part of the investigative branch and that alone, just like it is in South Australia, you'd still be able to explore corruption, but you wouldn't be the propensity for public mistakes and the public demolition of private reputation would be addressed. And I think that's the way to go.
I sure hope that people have been listening to your ideas for reforms, Chris Merritt. It's been fantastic to talk to you, but unfortunately we are out of time. Thank you very much for joining us today, Chris.
Quite okay.
That was Chris Merritt, who you can find at the Rule of Law Institute and his columns in The Australian on a Friday. I'm Monica Wilkie. Thanks for joining. We'll see you next time.